Tommy Dyson adopted multiple children, including 2 boys, both age 10. While attending a celebration for one boy's adoption, a court-appointed advocate saw a photo of one of the boys holding his shirt up and his pants down, exposing his private areas. The photo was seen on Tyson's phone as one child scrolled through photos. When the advocate questioned Tyson, he said the boys had been playing around with his phone. He returned to the photo and deleted it. At that time, the advocate saw a similar-looking video, which was also quickly deleted. CPS removed the children from Tyson's home and informed a deputy that there was a history of unfounded sexual allegations at the residence. The following day, the deputy went to the home and saw the phone sitting on the table. Tyson confirmed it was his phone, and it was confiscated by the deputy while a search warrant could be secured. Days later, Tyson's friend Janice called law enforcement to report that Tyson had given her a laptop and a hard drive, stating there was questionable content on each. Now, following his trial and conviction, Tyson is appealing to a higher court. He argues the warrantless search and seizure of his cell phone was unconstitutional, and that evidence found on his phone, laptop, and hard drive should have been suppressed. Let's take a look at the arguments.
State of Washington versus Tommy Darren Tyson. And as I understand it, Mr. Saunders, you've reserved 5 minutes for rebuttal, is that correct?
That's correct.
All right, go ahead and step forward when you're ready.
Thank you, Your Honors, and good morning. My name is Jason Saunders of Gordon and Saunders. I represent Mr. Tyson. We raised 3 issues in our brief: whether there were exigent circumstances that circumvent the search warrant requirement, whether the search warrants had particularity, and finally, whether there was probable cause under Aguilar-Spinelli. I'd like to focus on the first 2 arguments today. Start off with exigent circumstances. The law is very clear that if there's an opportunity to get a search warrant before a neutral magistrate, you must get a search warrant. Terry versus Ohio says to search or seize property, officers must get a warrant whenever practical. Here is a case where, I know you're very well of the facts, but I'm just, the few ones that really are germane, is that CPS contacted Detective Astorga on the 17th, the very day that a CASA worker had seen a picture of the young boy exposing his penis. The officer knew that there was a picture on the telephone. He knew that my client had deleted that photo, and he didn't get a search warrant. He knew about it on the 17th before 9 o'clock. It wasn't until the 18th after 9 o'clock that they went to the house. So in 24 hours, it was practical to get a search warrant, and there's been no discussion by the detective why it was impractical for any reason. We all know that there's telephonic warrants available. There was no discussion about courts were closed, judges weren't available, nothing in the record that said he couldn't have gotten a search warrant. So in this case, should have got a search warrant. The state really focuses on the fact that, well, once he arrives there and enters the house and there's a phone there, he grabs it and is exigent because then he'll destroy the phone. Well, what about those 24 hours?
Can I stop you for a second? So your position is that the information that the deputy had, which was a photograph of the child on the phone, and he was exposing himself in that photograph, that photograph standing alone provided probable cause for the search warrant?
Yes, yes, and
Okay.
that's the law is very clear. Probable cause, what you do with probable cause is you get a search warrant before a neutral magistrate. You don't wait for 24 hours for an opportunity.
I understand your argument. I just wanted to get, what I'm hearing is a concession from you that picture standing alone provided probable cause for a magistrate to issue a search warrant for the phone.
Certainly there was on his cell phone incriminating evidence that he had in possession of genitals of a minor child. So yes, there was enough probable cause to get that phone and do an investigation.
If I may, isn't it separate evidence that Benoit observed the photo, interacted with the child? Isn't that separate evidence aside from the actual photo? So what I mean is that's independent of any seizure of the phone. This is observation taken alone, which could contribute to probable cause in conjunction with the other external, other than the phone itself?
Yes, certainly the detective knew that he saw it, and obviously that evidence is incriminating. He explained what he saw to CPS that was forwarded to Detective Astorga. He knew it was on the phone. We don't know from any testimony whether he planned to get it if he could, but certainly that's evidence of a crime, and if he was really worried about the destruction, he could have done something to get the phone when Mr. Tyson went to Longview. If he was really worried about the destruction of evidence, he had 24 hours to do something about it, but especially get a search warrant.
So counsel, I want to go back to Judge Cruiser's question for you. So I'm going to give you a hypothetical. So if I have a child and I take a picture of my child's rear end, let's say, because I see a rash on it, so I now have committed a crime, or there's indicia of a crime on my phone because I took a photo of my child's rear end?
That's very interesting, and you know, we have all kinds of cases that go for, well, if I bathe a child and touch them in a certain place, then that would not be for sexual gratification. And certainly parents can take photos of their children. Buttocks is not as incriminating as other genitalia. And I would argue that, yes, it could be a totally innocent explanation, but I think there was enough reason to look at the phone and to determine if there was anything there.
So where's the harm? So the deputy shows up with a CPS worker, Mr. Tyson's not home. So they come back the next day. And so your view is that they could have shown up that first day with the warrant. They show up, he's not there, they come back the next day. What's the outcome of the fact that he takes the phone and then gets the warrant, takes the phone without looking at it, and then gets the warrant, as opposed to just showing up on the day of with the warrant? Where's the harm to Mr. Tyson about that minor difference in timing?
It's a harm to all citizens. The Fourth Amendment demands that you go before a neutral magistrate to seize any evidence. If you know about it, you must go before. Terry versus Ohio is very clear. It's a very old case.
Terry stops don't require any sort of permission from a neutral magistrate. That's the whole point of Terry.
If it's reasonable, you must get one. Exigent circumstances, and what we're really looking at for exigent circumstances, is it practical in any way to get a search warrant? If it is, there's no emergency available that you can't.
Okay, so if the deputy had the search warrant the first day, he shows up, Mr. Tyson's not there. So he can't get the phone.
Right.
Shows up the next day with the same search warrant, takes the phone and searches it. So there is, in your view, a greater intrusion on your client's rights because the phone sat as a brick doing nothing for a period of time before it was searched than being searched on that day. What does that have to do with the evidence that was presented in this case, that was retrieved pursuant to a valid warrant and was found by an independent source? What is that delay of the phone's just sitting here as a brick for a period of time waiting for the warrant, as opposed to it has that warrant, that first interaction?
It doesn't go to harmless error, Your Honor. It goes to the very violation. In the state of Washington, it's very clear that when you violate the protocol of getting a search warrant when you are able to, that evidence must be suppressed. It doesn't go to, well, wouldn't it be harmless because sooner or later they would.
You're not really elevating form over function. I mean, there's no difference in the outcome. The warrant was issued by a magistrate. It was searched. The evidence was found. And of course, the independent source doctrine holds that evidence obtained pursuant to a valid search warrant comes in irrespective of an earlier unrelated illegality. So why would that make sense for us to follow your view when you're conceding there's probable cause for the warrant? And there was merely a difference in, well, I didn't search it that day, I searched it a different day, and it sat undisturbed, it sat unmolested, no tampering of the phone, nothing happened. Where is this extreme intrusion on your client's property rights such that we would then suppress evidence, which is an extraordinary remedy?
Well, the remedy is any time when an officer doesn't follow the Constitution and impermissibly seizes something, reversal is automatic in the state of Washington. That's what happened here. I'm talking about Hendrickson, Walker, and all the cases.
Right, but you're not addressing independent source.
Well, first of all, the judge never found an independent source. And,
Which judge? The issuing magistrate?
the judge below in this case,
Judge Evans?
Evans, Judge Evans. So he never ruled on that matter, and if it's important to determine the independent source doctrine as a reviewing court, I would hope that the court would.
Law review's de novo, because that would have been a conclusion of law.
Yeah.
So can you go ahead and still address it?
Still address independent source. For the independent source, you know, what we have here is a strict violation, and we don't have any facts of what would have happened and what did happen, because the officer just plainly violated the mandate that you get a search warrant before you go to a house whenever practical. So I don't think there's an independent source that says, well, there was a mistake made and we can go ahead and violate the U.S. Supreme Court and the Washington Supreme Court and allow this to come in from an independent source doctrine.
Thank you.
I would also want to quickly talk about plain view. I think the judge below did correctly rule that the plain view exception did not apply simply because that phone was not immediately recognized as the evidence. I can talk.
The state did not cross-appeal that issue.
Pardon?
The state did not cross-appeal that issue.
That's exactly what I was going to say as well, Your Honor. I will reserve the rest of my time for rebuttal unless the court has any questions right now.
Thank you.
Thank you. Go ahead, counsel.
May it please the court, my name is Erica Agerson and I represent the state of Washington in this matter. Your Honors, in this case, Mr. Tyson purposely destroyed evidence of child sexual abuse on his phone. The deputy who was dispatched the next day to assist CPS was entitled to seize that phone based on exigent circumstances in plain view. And the warrants that law enforcement subsequently obtained were based on probable cause and were sufficiently particular.
Can I stop you just real briefly on the facts? You say Mr. Tyson destroyed evidence. Didn't he delete that picture at the mandate of the CPS worker?
No, Your Honor. Actually, the facts indicate that the CASA that was present at the adoption breakfast asked Mr. Tyson to show him the picture. And instead of doing that, Mr. Tyson brought up the phone and deleted it. And so in addition, and this relates to the court's questions about probable cause earlier, in addition to the fact that the CASA saw a picture which indicated that this child was purposely exposing his genitals so that Mr. Tyson could take a picture, we have both the child and Mr. Tyson avoiding any efforts of the CASA to look at this again to ensure that this child is not being sexually abused. So we have consciousness of guilt. We have a child who's acting as if he knows that this is something that is supposed to be concealed from view. And importantly, with respect to the rash question that was asked earlier, this is a 10-year-old. So it's not a toddler in a bubble bath type picture. It's a 10-year-old. And that fact matters, the age. And Mr. Tyson didn't say when he had the opportunity that, oh, this was for medical purposes or I needed to take it for this purpose or another. He said the boys were messing around on his phone. And importantly, that reveals that Mr. Tyson knew this picture was on the phone. He didn't delete it. He purposely kept it there. So there's absolutely probable cause for Deputy Astorga to believe that that there is evidence of child sexual abuse on the phone.
And Mr. Tyson's counsel just conceded that there was probable cause for the warrant.
Correct, Your Honor. I did want to address the court's questions just in case the court had lingering questions about that issue. I respectfully disagree with opposing counsel that exigent circumstances require that there had been no possibility prior of obtaining a warrant. That's simply not the case. The question is whether there was exigent circumstances at the time. And it's clear that here there were. Deputy Astorga was just that. He was a deputy. He was not a detective. He was not assigned to this case. He was dispatched to assist CPS. He did inadvertently come across information that first day he's dispatched about what was going on and what might be on the phone. And then he's dispatched again to assist CPS to stand by while they take children out of the house. He was not searching for evidence. He was there. It's clear from admitted Exhibit 1. He's clear keeping an eye on Mr. Tyson in the front room when he notices the phone. And when he does notice the phone and he knows what's likely on that phone, it's a now or never situation. Phone is mobile. It can be easily destroyed. Mr. Tyson has already demonstrated that he is capable and willing of destroying evidence. And potential evidence of child sexual abuse is on that phone. So that's the correct situation to look at. The exigency in this case is what's going on when Deputy Astorga inadvertently comes across this potential evidence. And again, it's not necessary that law enforcement conceivably could have obtained a warrant earlier. The question is not conceivably what it could have done, it's whether what Deputy Astorga in those circumstances did, whether that's constitutionally permissible. And if the court has questions about that, I think State v. Mohammed, or Washington Supreme Court case is instructive. And in that case, police got a search warrant to search the defendant's vehicle. They surveilled the vehicle. For some reason, they stop surveillance and the vehicle disappears. So they had a chance to stop the vehicle based on their search warrant and obtain evidence, but they didn't, and so they subsequently get a warrantless ping of defendant's phone based on exigent circumstances, and the court upheld that course of action based on exigency. It did not matter that law enforcement could have conceivably stopped that car and searched it pursuant to the valid warrant. So it's just not a requirement that law enforcement conceivably could have done something different. The plain view doctrine in this case does apply, and I do believe the court can consider it because this court can affirm the seizure of the phone based on anything supported by the record, and plain view is supported by the record here. We have Deputy Astorga enter the house. He learns that that phone is Mr. Tyson's. It's immediately apparent to him as evidence. He knows that even though Mr. Tyson attempted to delete the picture off the phone, it is likely still on that phone. He still has probable cause to believe that it is evidence.
Well, what's the upshot of a seizure without search of this phone? If there's an observation of destruction of evidence of a naked 10-year-old showing genitalia, of evasive conduct, and that observation that Benoit makes is then later coupled with other information to obtain search warrants to get to these devices. What's the remedy if they seize this phone for preservation purposes and yet don't obtain search warrants later with that image?
Well, they do obtain search warrants later.
Yes, but aren't those affidavits independent of that particular image?
Well, the affidavits for the search warrant combined that information with other information that subsequently came to light.
But the image, I mean, did it have a picture of the image to show?
No,
Right.
The image is not in the search warrants.
Right.
But that makes no difference as far as probable cause is concerned, because what we do have in the warrants is a recounting of Mr. Benoit's observations along with a recounting of two other people's observations. And all of that combined, the totality of the circumstances provided probable cause for search of all of those devices. And addressing warrant particularity, the trial court in this case was absolutely correct that all of the warrants issued in this case were sufficiently particular, including the first one in 2017 and then the two subsequent warrants that were executed in 2020. Looking at the warrants, none of them suffered from the same problems as in McKee or Basola. In those cases, specifically, the warrants authorized searches for possession of depictions, but there was no definition of sexually explicit conduct, which would enable the searcher to differentiate between protected materials and evidence of crime. These warrants all did contain that definition. The first warrant was limited to photographs, and with that definition was sufficiently particular. The searcher knew they were looking for photographs that constituted sexually explicit images of minors. And then the 2020 warrants were sufficiently particular for the same reason. They contained greater information as well about date ranges and the specifics from the people who provided information that put together probable cause. And specifically, the affidavit was attached and incorporated by reference, so that gave additional information to guide the searcher in differentiating materials for which there was probable cause and differentiating those from materials for which there was not probable cause. And with respect to the warrants as well, there's just simply no debate that those warrants were supported by probable cause. There was no Aguilar-Spinelli issue here. Aguilar-Spinelli is a test that looks at the reliability of hearsay information. It looks at knowledge and veracity. The knowledge prong basically asks if the people who supplied the information had personal knowledge. That was verified here. All of the three individuals who provided very detailed information had personal knowledge. And then we have named citizens who are presumptively reliable. And the information they provided put together paints a very clear picture of Mr. Tyson's possession of depictions of minors engaged in sexually explicit conduct. So all of the warrants were supported by probable cause.
And counsel, I'm not sure what you're to do with counsel's concession. I guess I'll ask counsel in his rebuttal if he's withdrawing several of his assignments of error, because he conceded on his direct argument, or his opening argument, that the picture that was seen by the CASA worker standing alone provided probable cause for the warrant. So I'm not sure if the Aguilar-Spinelli issue is still a live issue.
Well, my understanding of counsel's concession was that he conceded that it provided probable cause for seizure of the phone. I did not take his oral concession as probable cause for what was underlying the warrants, but this court may
I
have
asked him
better.
if that standing alone was probable cause for the warrant, and he said yes. So I'll ask him on rebuttal if maybe I misheard it.
No.
That may have
Okay.
been my misunderstanding as well,
Okay.
Your Honor. But just in the interest of addressing all arguments that were raised, the state takes that particular position.
Now, did Travis and Roland Erkenbrack need to see this quote-unquote questionable porn, or need to see the image of the child holding Tyson's genitals?
No,
Or they had to, for basis of knowledge, they just had to relay what Tyson told them, right?
correct. There is no requirement that somebody actually see the photographs at issue. It was sufficient for Ms. Roland Erkenbrack to tell police that Tyson says there's a photo on his device of a child holding his penis. That's sufficient, especially when we put it together with the surrounding circumstances, where it's not just Tyson's statements, it's his actions. He's taking active steps to destroy all of his devices. His brother sees him as soon as CPS and Deputy Astorga leave, frantically trying to erase things, putting devices outside, trying to get he and his mom to take devices, making a comment to he and his mom about taking care of the children in case Mr. Tyson goes to prison. And so if there were a situation where it wouldn't be sufficient to just pass along a confession of somebody, we have all of these surrounding circumstances adding to that confession that's being passed along. So all of those surrounding circumstances, viewed in the totality of the circumstances, which warrants are supposed to be evaluated on, are sufficient in this case.
I don't have any more
I don't have any
questions.
additional questions, counsel.
The state respectfully asks this court to affirm Mr. Tyson's convictions. Thank you.
Thank you very much.
Your Honor, I'm sorry if I wasn't clear about that. Yes, we were talking about exigent circumstances and the seizure of the phone, and I was just talking about there was probable cause to get a search warrant and seize the phone. I
Okay,
wasn't
so-
talking about the searches.
So if there's probable cause for a warrant based on that picture alone, as reported to Deputy Astorga from the CASA worker, what difference does it make? Your assignment of error number 4 relates to the reliability of the folks who provided evidence to the deputy that then was used in the application for the search warrant, and you're saying these folks are not credible and whatever. what are we to do with that assignment of error when you've just conceded that there was probable cause to obtain a warrant based on that picture alone?
To seize the phone.
And obtain a warrant. Your argument is that you can't seize the phone without PC for the warrant because you had to have a warrant. And so you said, yes, there's PC for the warrant. So if there's PC for a warrant, now probable cause and seizure, according to your argument, the basis for a seizure and a search are the same, probable cause.
Well, yes.
Oh, okay, so are you saying that
Yeah,
the seizure doesn't
no,
need to be-
I totally agree. I think you have to have probable cause to seize the phone, and then, of course, you need a search warrant with probable cause to describe what's going to be in what you're...
I'm not talking about your particularity assignment of error, let's be clear. That's different.
Okay.
You're talking about, particularity is more about talking about what you're gonna look at.
So you're speaking...
I'm talking about your Aguilar-Spinelli argument, so you give information to the magistrate saying, here's why I believe there's probable cause.
Right.
I was told there's this picture, and Tyson admitted there's this picture, and here's what the picture looked like, and then I also spoke to these folks, and that comes together. And you're saying that this alone was enough, so why should we spend time on whether this stuff was good enough for a PC when this alone, according to you, was enough to get a warrant?
They did more than just search the phone for that picture. They searched...
Again, that's your particularity argument. That's a different argument.
Well, the search warrant, when we were talking about the veracity of the people who corroborated that there might have been one picture on the phone, that is used for probable cause to have a search warrant, right?
For child sexual abuse material.
Yes.
Right.
Right.
Okay.
And my argument for that is that wasn't sufficiently reliable evidence and they had no firsthand knowledge.
But if you already have PC to search the phone for child sexual abuse material, and these folks didn't provide any evidence that would have pertained to different parts of the phone you search. I mean, when you're searching for child sexual abuse material, that can be in any number of places on a phone. So it's not as though knowing about the picture meant that, okay, I only need to search this one little area of the phone, but then these folks came in with additional stuff, so now I'm going to search more of the phone. Do you follow what I'm saying? If you're searching for child sexual abuse material on a mini computer, i.e. a phone, and it can be in files, it can be in text, it can be in Facebook messages, it can be da-da-da-da-da. How does that information, even if we take your argument at your word that those folks were not reliable for the reasons you state, if you've already conceded that the picture alone is PC for child sexual abuse material on the phone, what are we to do with that Aguilar-Spinelli assignment of error?
I think it only goes to that one picture. I don't think it goes to anything else. It doesn't go to the search warrant for anything else.
So that wouldn't be for any other child sexual abuse material, it would only be for that one item of sexual abuse material?
Yes.
Okay.
And then there'd be argument, at a trial of whether or not that was just the boys messing around or not, but that's the only thing that the search warrant would have in it, is that one photograph. And that goes to the particularity argument as well, because they're searching the phone for absolutely every picture known to man instead of having dates of when the boys were in the house, what kind of files they're looking for. Are they looking for JPGs? No relevant dates. And that's why it's not sufficiently particularized and why it needs to be. Lastly, I want to really quickly talk about the first statement of additional authority that the state filed. And if I may quickly say, they talk about harmless error for the very first time in the statement of additional authority that doesn't support any arguments that they made in their briefing. I know that this court is very aware that you won't accept arguments raised on the first time in a reply brief. This is an argument raised for the first time in a statement of...
I will state, since both parties are here, counsel, it really is not appropriate to take a statement of additional authority as a second and third briefing opportunity. Both of the statements of additional authority contained information that could have been included in the brief. Statement of additional authority would typically be appropriate when there's a new case that came out since the briefing that impacts the assignments of error or the arguments made, but to come back and cite cases from, 10, whatever years ago and say, oh, by the way, there's also this. I haven't spoken to my colleagues about this, but I don't regard that as an appropriate use of statement of additional authorities. And it also is not terribly helpful when it's filed so close to oral argument because counsel can't respond.
And any response I can have is 350 words.
Right. So with that, thank you very much.
Thank you.
Following these arguments, the court affirmed Tyson's convictions. They concluded the warrants were supported by probable cause and were sufficiently particular. He had been sentenced to 11 years to life for these crimes. Is this enough time? Let me know what you think in the comments below, and please hit subscribe for new arguments every week.